number 130, matter of Prometheus Realty Corp. Versus the New York City Water Board. Counsel? Good afternoon, Counsel.
Good afternoon, Your Honor. May it please the Court. Melanie West for the New York City Water Board and Department of Environmental Protection. I'd like to reserve 3 minutes for rebuttal.
3?
Yes.
Very well.
We are here because petitioners have challenged the New York City Water Board's decision to issue a one-time $183 credit to New York City's small homeowners.
So why is the board imposing the 2.1 rate increase, which is based on the rent that has to be paid to the city when the city has said you don't have to pay the rent?
Well, the 2.1 rate increase was set before the rent forbearance, but it wasn't based entirely on that. It was based on a 5-year projection of the water board's budget. And
So when the city proposed the rent forgiveness, why wasn't the gap closed, the financial gap, that $76 million or whatever it was?
Right. The question that this court has to answer is whether the only rational thing that the water board could do, whether in fact the water board was compelled to close the gap simply because after it had proposed a 2.1% rate increase, based on a number of factors, the city decided to forbear from collecting the rent. It's simply not the case that there's anything in the statute or anything anywhere else that compels the water board to have used that money in this one fashion alone.
What does the law authorize you to, what's the basis under law for a rate increase?
Well, the statute simply gives the water board broad authority to fix rates. It doesn't enumerate any particular factors. The system is supposed to be self-sustaining, but certainly the water board is allowed to and has throughout its existence planned rate increases with a long-term view in mind.
And if the water board makes a determination that we need the 2.1 because we want to close a gap, and then that gap doesn't exist, can the water board change its mind and say, well, we're still going to go ahead with the 2.1? Is there anything in the law that prohibits it from doing that?
There's nothing that prohibits it. And I think the record reflects that while...
What would the 2.1 go to if you no longer have the gap?
So the record reflects that when the water board decided to retain the rate increase, and they held the public hearings, that was addressed. And so the board explained that there were numerous capital projects and infrastructure projects that the rate increase would go towards. It would also help to ensure that future rate increases were incremental rather than drastic.
So after deciding the 2.1, could the water board have said, you know, we've decided it's going to be 20%?
Well, I think that goes to the rationality, is looking at the actual substance of any decision.
Yeah, but you said the board can look and have a long-term vision, so I want to look at the next 40 years.
Right, I mean, 20%. Theoretically, yes, if some rational basis could be offered for that. But, you know, the more drastic something like that gets, the less on its face it appears rational.
Why is it rational if the board has articulated that the 2.1 rate increase is to address this shortfall that then no longer exists, to continue to impose the 2.1? Yeah, it's not even shifted. It's not even
that's
a
1 minute
1.0,
entry
right?
into the record, Your Honor, but the record does reflect that there were other factors in play. And so when you look at the public hearing transcripts, which post-date the budget shortfall being filled, you know, the water board officials addressed that by explaining that, in their view, it was in the best interests of everybody to maintain the rate increase in order to fund capital projects, to ensure that rate increases remained incremental, and to use this amount of money for something else, in this case for a $183 credit for Class 1 homeowners.
Is this the first time that the board has ever granted, for lack of a better word, a blanket credit to an entire class based on their tax classification?
My understanding is it's the first class-based credit. There have been other credits.
What are some
and
of
there
the
have
other
been-
credits? Aren't there a series of other credits that the board has given to commercial developers, to Class 2 members, to senior citizens, to
Yes.
frontage transition users? Hasn't that been done a number of times in other policy alternatives that the board is engaged in?
Absolutely, Your Honor. There's a long history of differential rates, some of which have taken the form of credits. For example, there are credits for seniors, for individuals with physical disabilities, and some of which have taken the form of rate mitigation. So, for example, the Frontage Transition Program, for over 2 decades, afforded rate relief in the form of a choice to remain on flat rate billing.
And who did that benefit? What class did that benefit?
That benefited the bulk of Class 2 owners. The Frontage Transition Program
And
benefited
just
anyone.
describe for those of us who live outside New York City what Class 2 owners are.
So Class 2 is 4+ units in a home.
So
The
these are-
Frontage Transition Program benefited 6+ users in a home, and then when it was transitioned into the Multi-Family Conservation Program, it was applied to all
Right,
Class
and Class 1, of course, is 3 or less units.
3 or
is that-
less, that's right.
I
But
see.
you said the bulk of the class members? Is that what you said?
Yes,
What does
6+
that mean?
units.
The 6+ units?
The Frontage Transition Program applied to 6+ units.
Mm-hmm.
When that was phased over into the Multifamily Conservation Program, which
So now
effectively a very
the
similar.
frontage transition unit, this arose because of the transition from a flat water rate to
metered
metered
billing.
water rate. Is that correct?
Correct.
All right.
And
It-
that
What
was.
would
an-
the financial impact of that be? Do you have any idea?
It was anticipated that the impact would be large, particularly on larger buildings, because they use more water. And in order to lessen that impact, and particularly with the goal of protecting affordable housing from being severely impacted by the switch to metered billing, the board introduced these programs of rate relief that were available not specifically to affordable housing, but generally to buildings with 6+
Is
units.
there a difference between giving a credit, or as you say, a rate mitigation, or just differential rate treatment? Are those things the same, or are they different in impact?
Well, I think the difference of the impact is that a credit enables money to go to the pockets of New Yorkers immediately. A rate mitigation takes longer and can have lesser impact, particularly when you're talking about a fairly modest pool of funds like we are here.
But in terms of the authority of the board, is there any legal distinction between those things?
No, Your Honor, there's nothing, and the lower court, the appellate division did hold that there was nothing in the statute or elsewhere that prevented the board from issuing a credit. And indeed, they have
Well, I
issued
guess at
credits
its
before.
core, though, you'd have to say, is this rate reduction any different than a property tax rebate that we do on a statewide basis? It seems to be very similar to that kind of give back. And the only thing that strikes me about it, the only thing that I would say is the one question that come up before, which is that the justification for the rate increase has to be linked to the services of the water board. So if the money isn't being used for the fire department or for something like that, then you have a stronger policy argument. And that doesn't seem to have occurred here, has it? Has it?
No, Your Honor, so it's certainly not.
Thank you, counsel. Counsel?
Good afternoon, Michael Berengarten of Herrick Feinstein on behalf of the petitioner respondents. I want to address some of the questions raised about what the rational options available to the water board were after the city announced a rent forbearance, which obviated the stated justification for this particular rate increase. But first, let me just basically give you the big picture in terms of our arguments on the merits. We principally argue on the merits, and 2 courts have now agreed that there's no rational basis to single out only one Class 1 property owners, the minority of residential households in the city, to receive a bill credit without regard to their income, their economic need, their property value, or any rational
Aren't
water-related
there a number of
purpose.
programs that are already doing that now? That benefits were given to people on the basis of the frontage transition program, on the basis of the class they belong to.
That's actually not correct, because
Okay.
if you consider the frontage transition program, as a threshold matter, it had eligibility criteria designed to serve a specific purpose. The eligibility criteria initially were directed based on the diameter of your service line, and then subsequently extended to property owners having 6 or more units, excluding new construction, and the
Some
purpose.
of those property owners were very, very wealthy, right? And some were probably of very limited means,
So
correct?
that question has the assumption built into it that all property owners eligible to participate in the transition program actually received an economic benefit from this program. Unlike the bill credits, that's not true. It wasn't a giveaway to an entire tax class, because savings based on the metered rate were only principally realized by more densely populated buildings where, buildings are typically overcrowded. So when you have more densely populated buildings, in that instance, you're likely to utilize more water.
Do you agree that the water board could charge different rates to Class 1 versus Class 2 or 6+ units or whatever? They could charge different rates, right? Is that right? For the same service? Could charge different rates?
No, actually,
No?
water is charged generally based on consumption, such that all accounts pay the same metered rate because
What
it's
about
based on the cost
sewer?
of delivery.
Is that
With the-
also based on consumption? Sewer, water and sewer?
this petition doesn't present those issues with respect to sewer charges, but water is charged based on consumption. So all accounts are charged the same metered rate, with the exception of those rational programs that were previously instituted by the board.
So it doesn't have to be charged directly based on consumption?
No, it doesn't have to.
Okay,
So for example,
So just bear with me for a second. So if it's not based on consumption, and if the water board can make a choice to charge different groups differently, then what is the practical difference between lowering the rates, giving them a rate abatement or whatever, versus giving them a one-time credit, as
well,
they
the
did
question
here?
is, what is the reason for the rate variance? What the water board can distinguish between and among customer classes, but there has to be a rational basis.
Well, but isn't
for-
that a policy choice that the board makes, that to say, I want to benefit homeowners that have 3 or more units, and this is how I'm going to do it? And I've given these benefits to senior citizens. I've given these benefits to people that have 6+ units. Why can't they make a policy choice to give a particular benefit in a particular form to a particular class of property owners? Why aren't those pure policy choices and not legal questions?
Well, that just.
I mean, you can certainly dispute the policy choices, I'm not saying that, but how does this become a legal question for us to get involved in?
That just states the action taken. It doesn't state the rational basis. For
You
the
tell
action.
me how it's not a policy question as opposed to a legal question.
The reason why, it's not a policy question because water is charged based on consumption. In order to issue these
But
credits.
it's not really charged on consumption, right? Because there's still 10,000 Class 2 units out of the 26,000 that are charged on frontage.
Well, that's no longer the case. That ended a long time ago. But again, the frontage program didn't benefit an entire tax class.
I'm sorry, is that in the record somewhere you can point me to, that there are no Class 2 units that are charged on frontage now? They're
Yes.
They're all metered?
The frontage program ended in 2012.
I'm sorry. Is there somewhere in the record you can point me to?
The reason it's not in the record is because the frontage program was
So
first
the answer is
raised.
no, there's nowhere in the record you can point me to.
That's correct, because the frontage program was first raised on appeal by appellants. It was never even brought to the lower court's attention. And the principal point with respect to frontage is that it didn't bestow a benefit on an entire tax class, even to all eligible participants. The frontage rate was deemed only more beneficial to more densely populated buildings, typically housing lower income tenants. And that's why its policy was consistent with the home water assistance policy, which directed relief from the metered rate to more densely populated, to more vulnerable customers of the system.
But now it sounds like you're answering Judge Fahey's question as this is a policy matter.
So the question is, what is the rational basis to increase rates on the majority of residential households in the city? Just as Class 1 owners include wealthy homeowners, so do Class 2 owners include persons of moderate and low income who are required to pay increased water rates to fund this credit.
Sure, I understand the inequities in any policy choice. I'm not arguing that with you. I think that you have a legitimate point there, and they were pointed out in the lower court's opinion. That's understandable. The only question is who should make the call, really. You have these set series of costs, and they're distributed. How are those costs distributed, and who should make the call to make those costs? And you don't like the way they distributed the costs here. And those seems to me to be fundamental policy questions and really not legal questions unless it's so irrational that it violates some constitutional right, which I don't see here, I guess. I just don't see it. I don't see it as ultra vires, I guess is my point. And that's why I'm asking you these questions. I want you to point to me how it is.
Well, Your Honor, the question is, how is it rational to just give away $122 million to an entire tax class if it's not consistent?
My God, I could run through tax breaks that people get every
But the
single
water
day.
board
The
doesn't have
both of us
taxing
could do
authority,
that
right.
until the cows went home, and those tax breaks would seem really egregious to me, and I'd say, why can't I get that tax benefit?
Because
Why
the water
can't I
board
write those
doesn't
things
have
off?
taxing authority. They have the ability to implement service charges.
Well, yes, we're talking about rates, but do you agree that the board could say, okay, well, there's no deficit next year, but we're anticipating a deficit 2-3 years out, and it's going to be probably substantial, and so rather than hit everybody at that time, we're going to just do it in increments, in stages.
Absolutely. So to
Okay,
the
so if the board can do that, why can't they still implement this 2.1%, even though it may not be necessary for this coming, year?
Right, because
fiscal year?
the board had two options available to it. One, the most expedient option, not raising rates, move into the next fiscal year with a $46 million surplus, and then readjust your baseline rate and set your rates for future incremental rate increases to the extent necessary. That option was available to it, and in fact, it's required under its financing agreement to revisit its rate every single year and reconsider the conclusions in the annual report of its rate proposal. Alternatively, the board could have gone back to the drawing board and thought of whether or not that a rate increase may support rational programs, projects, reserve requirements that were not budgeted. But the water board didn't do that. Under this rate schedule, what the water board proposed to do is simply increase rates in order to take that $76 million in revenue together with the $46 million from the projected surplus, and then give that away to Class 1 owners.
Well, could they have done something else with it? Could they have taken that surplus and applied it to something that they didn't budget for because they didn't think that it was absolutely necessary, but it was certainly a desirable thing to do? And it didn't involve giving money back to anybody. It involved putting it somewhere else in the system. Could they have done that?
Absolutely, and that's
Okay,
why...
So then why is that not a policy choice?
It's not, because the water board, the trial court decision, the trial court didn't enjoin the water board from doing that. They only enjoined the water board from implementing this particular rate schedule, providing for these bill credits, until further action. So my point was that the board could just go back to the drawing board and budget for rational reserve programs to the extent they desire to increase rates. But they didn't do that here. And just briefly to go back to your question.
Counsel says that they did actually explain this 2.1 increase was not solely to close the gap. Do you agree with that?
Absolutely not. The documents...
Where in the record does it show otherwise?
Well, for example, the board's minute meetings explain that the 2.1% rate increase...
Yeah, but she says beyond the minutes, there's other documentation that shows otherwise.
No, that's not correct. The only argument that Mr. Lawitz made in his affidavit was that the board desired to adhere to a 5-year plan of projections. However, everyone knew at the time that those projections were invalid because they were based on the assumption that rents would be owed through fiscal year 2020, when in fact, the rent forbearance was applied for those 5 years. So the board would necessarily have to, in the ensuing fiscal year, go back to their rate proposal and set a new baseline rate and adjust their projections. But
if they had indeed showed somewhere else in this record that they were taking into consideration future costs, or as she says, we want to make it self-sustaining, we want to look across the board at other programs we want to do, if that is actually in the record, Do they win?
Do they, I would need to understand, there's nowhere in the record that would indicate that this rate increase was designed to support reserves or any other rational projects or programs exclusive of these bill credits. And the Water Board does not have taxing authority. It doesn't have the ability to just say, we as a policy-making body want to issue a tax credit. The Water Board is authorized to issue service charges. And so, yes, to the extent its charges are not based on consumption, they have to be consistent with rational purposes, consistent with the board's mission here. And the board's mission wasn't served by raising rates on the majority of residential households to get $76 million and then drawing down a $46 million surplus solely to give it away without regard to whether it supports water conservation, assisting vulnerable customers of the system, system efficiency. In what realm did this?
So if the mayor indicates what he wants to happen with this money, can't they take that into consideration? And can't they fear that if they don't, there won't be future forbearance regardless of what has been said now in the moment?
So to answer that question,
Yeah.
while the mayor proposed the bill credits, it's the board's statutory duty to apply its independent judgment consistent with its mission. And the mayor didn't.
But I think the point is that if they did that, an independent analysis, they may have thought that it was a pretty good idea to do what the mayor had proposed, because it would be to the board's benefit in the long run. They would get more out of that than they would lose.
Your Honor, proper determinations can't be based on presumptions or fears that are unsubstantiated in the record. And here, the city already announced the rent forbearance not just in fiscal year 2017, but through fiscal year 2020, when the mayor proposed these credits for the board's independent judgments.
Well, let's say they would not renege on the 2020, but there's water after 2020.
I'm sorry.
They might worry about what would happen post-2020, correct?
But if you consider why the mayor proposed the rent forbearance, it has nothing at all to do with these credits. The city stated that the rent forbearance was intended to limit water bills to the cost of water and dedicate fees solely to the system, which is entirely consistent with the Water Board's mandate and entirely inconsistent with raising rates and drawing down a surplus to give them to Class 1 owners.
Well, you see why before I was bringing the property tax rebate issue up, not on the taxing question, because the underlying your argument is some government agency is taking my money away and then that they don't really need, and they're giving it back to a certain group of people rather than to everybody in this particular form. Let me finish. State tax, same thing. State takes the tax money in, and then they give us a rebate on property taxes. Why did they just not take it to begin with? Why are they picking and choosing? Those decisions, like in property tax, they've been consistently upheld as policy choices. I'm trying to see how this is much different as a policy matter, even though it's not a taxing question directly. It has to do with the water bill. It's a little different. It still amounts to the same thing. They're taking money away, and then they're giving some back to a selected group of people.
So the answer is why. It's
Well,
a
they made a
question.
policy choice. Why? You mean, what are the
What is the
motivations?
basis for that policy decision? Is it based on the notion that Class 1 owners are needier or more deserving? Because these credits weren't in any way tied to financial
It seems to
need.
be that it was, because the Class 1 owners hadn't gotten any of the other kinds of relief that any of the other owners had, and a substantial portion of the Class 1 owners were people of more limited means, and it may not have been administratively feasible to go through a complicated application process for a $183 credit.
So to respond to-
That's
to
answering
respond to
your
that-
why.
That's factually inaccurate because many of the Water Board's prior water-related initiatives were open to Class 1 accounts. We cited, for example, the Home Water Assistance Program, the freeze of the minimum charge, the cap for all residential premises that comply with certain conservation measures. In fact, if you consider that the Home Water Assistance Program is only open to eligible Class 1 through 4 homeowners based on the legitimate objectives it serves, that program was primarily directed to Class 1 accounts. Same with the freeze of the minimum charge, in that it was based on consumption thresholds, approximately 95 gallons a day, in order to obtain the right to be billed based on fiscal year 2014 rates. Most larger buildings didn't qualify for those accounts. And again, while there are certain programs, that likewise served rational purposes which weren't open to Class 1 accounts, like, for example, the MCP, which required, in order to achieve or in order to be billed at the flat rate, investment and cooperation in conservation efforts, right, and was designed to be revenue neutral to the system and as a whole, and the transition program, which didn't bestow benefits.
Counselor, if there was no forbearance on the rent charges, and the board had decided, we're going to give a credit, but to pay for that, we're going to charge 3.1 instead of 2.1, could they have done that?
The question is, what is the rational purpose for the credit? In other words, is it consistent with the board's mission? Does it promote its policy objectives?
We want to put this group on equal footing, considering all the past credits and programs that we've had in the past.
So is that supported by the record, by reason? 'Cause
If
here
it
it's
was,
not.
right. Could they have done that?
If it was,
Yes.
in other words, make rational value-based determinations, sure, it could. But here, the record clearly shows that this was not a rational value-based determination.
Thank you, counsel. Counsel?
Thank you, Your Honor. I just want to start by pointing the court, just a quick record site on page 457 of the record is where during the public hearings, the 2.1% was explained. And this was after the rent forbearance was announced. The other quick thing I want to point the court to is on page 181 of the record, you can see the rate schedule, the current rate schedule, and you can see that the multifamily conservation program is still based on frontage-based billing, so that still exists. What petitioners
So
have
if we
argued...
didn't have the forbearance,
I'm sorry?
if there was no forbearance,
Yes.
could you have given the credit and just raised the rates a little higher? Could you have done that?
I think so. I think the forbearance helps to explain better why such a credit would make sense. There was an unexpected pool of funds that the board was faced with the question of what to do with them after it had set the rate schedule. Things might look a little different in a different scenario. I think, yes, they still had the
Let
authority
me ask you
to
a
do
different
it.
kind of question. Could the city have sent $183 checks, not give you the forbearance, just sent off the money? Could it have done that? You may not be able to answer that, but I figure you're from Corp Counsel, maybe you have some thoughts.
I'm not sure, but certainly I don't know anything that says they couldn't.
The selective, right? Selecting a particular tax group to give them $183 checks.
Right.
City could have done that, okay.
I'm not aware of any reason that they couldn't. What petitioners have argued throughout, including here today, is that the most expedient solution was a rate freeze. That may be the case, even if it were true. That doesn't mean that the Water Board was compelled to do it. At bottom, this case is about deference, about what it means to subject an administrative agency's decisions to rational basis scrutiny. Here, the board was faced with an unexpected, fairly modest sum of money. It decided to target Class 1 homeowners who had been excluded from decades of rate relief available only to Class 2 homeowners. It decided to do so in a way through the form of a credit that would deliver immediate, meaningful financial relief. And it decided to do so to an already established class of users so as to avoid administrative costs associated with trying to enforce eligibility criteria or some other, application process for the credit. All of that is rational, and petitioners have never explained why the board was compelled to take the action that they find preferable. This court has recognized time and time again that a perfect fit is not required for rational basis, that you can point to exceptions to a class, and that doesn't invalidate the rational basis for the class. And so affirming this case, affirming here would invite judicial second-guessing of every decision by a rate-setting agency that involved a differential rate. This court should reverse.
Thank you, counsel.